Hey, everybody, and welcome back to another episode. My name is Dana, and I will be your host today. And our guest is Christoph Mlinarchik. Hello, Christoph. How are you?
Hello, howdy, and good morning. I'm doing great.
Good, 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 good. So before we dive into our topic, why don't you take a minute just to share with everybody a little bit about you, what you do, and all that kind of good stuff?
Sure. So I'm Christoph. I'm a former contracting officer for the United States government. I worked for several different DoD agencies. I also did a rotation as a JAG acquisitions attorney. But now I'm in the private sector and I own a small business, ChristophLLC.com. I help out government contractors and subcontractors as a consultant, and I also do professional instruction and training. And I also serve as an expert witness in complex government contracts litigation. And my online courses, in addition to my in person and webinar stuff, I actually have recorded online on demand courses, and those are available at courses.christophllc.com. I'm also the author of the 3 books in the Government Contracts in Plain English series, and those are available in Amazon, both in paperback and Kindle.
And who would be the perfect person to take your course and read your books? Would they be government contractors? I'm assuming.
Yeah, government contractors, anybody remotely related to the industry of government contracts. I have courses that cover both beginner and expert level topics. So a typical person taking my course might be a program manager, a government contractor, a business owner. Maybe there's somebody involved in the cybersecurity world, since that's becoming so important to government contracts. Anybody who's ever used that phrase government contracts in their job would definitely benefit from my online courses at courses.christophllc.com.
Well, I am sure you are a wealth of information when it comes to this stuff. And I know as CMMC starts popping up all over the place, people will have more and more questions about their contract that maybe they didn't really pay attention to before that they are going to need to. So, yeah. So our topic today is obviously we're going to talk about government contracts. And our first question is going to be, how does the US federal government enforce policies or companies? Meaning, like, for example, how is the DoD going to enforce CMMC requirements?
The short answer is through a clause in your contract. In the world of government contracts, the way the government enforces their policy is through the contract itself. It's not like other forms of government regulation. In government contracting, you really have to pay attention to that document. The contract is your business relationship. And the broad pattern of how this policy works, usually Congress will pass a law, and that law will probably instruct the federal executive agencies to draft regulation. And that's exactly what we've seen with CMMC and with other cybersecurity requirements. Once they draft those regulations, in our world of government contracts, those regs are usually going to be in the FAR, the FAR, the Federal Acquisition Regulation, or in the Defense FAR Supplement, which is the version of the FAR used in the Department of Defense. So Congress passes a law, the executive agencies draft a regulation, usually a FAR or a DFARS clause, and then the contracting officer who works for the government, they're going to have to place that clause in your contract for it to take effect. And that's for a prime contractor. That's for a company that has a direct contract with the government. Now, if you're a subcontractor, it's going to get to you also by your contract, because the prime contractor will have a responsibility to include some or all of those FAR or DFARS clauses from their prime contract with the government into your subcontract that you have with the prime contractor. So that's why I focus on the clause. It's all about that clause in your contract, and it's all about the rules that apply to when that clause must be placed in the prime contract by the government or into the subcontract by your prime contract negotiating partner.
So let me see if you can help me with this. So now, when CMMC starts getting dropped in these contracts, is the contracting officer going to specifically go out of their way to make sure that the contractor understands that this is a whole new world here? This is not just self-attestation, that this, may be a big deal that they need to prepare for? Or how does the contractor really know that this is something you need to start taking seriously?
Well, the burden is really on you, the company, the contractor. You might get lucky and you might get a really involved contracting officer that gives you the warning that you're talking about, but no, 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 no. You cannot expect that. That's probably not going to happen. what's probably going to happen is at some point when these CMMC or other cybersecurity clauses become mandatory, they're just going to start to appear in your prime contract. It's very unlikely that you'll get some kind of a special warning from the government. They'll be just like any other government contract clause. The burden will be upon you to stay abreast of these changes, to understand these requirements that are found in your contract. And that applies whether you're a prime contractor or a subcontractor. The other party isn't really required to give you a foot stomp or an extra highlighter note or a sticky pad note or anything like that at all. This is probably one of the reasons why it's so important to have a contracts expert on your team to go over these draft documents, to help you with the negotiation and to explain the requirements of them, because your business relationship, your responsibilities, that is the contract. That's why we draft these contracts.
Well, what makes me nervous with this is that, there's a lot of mom and pop organizations in the DIB, and do they necessarily have a contract specialist on their team? Probably not. And they may not be, let's say it's a renewal contract, they may not be thinking, well, let me go look at this and see exactly what the differences are. So that's the word that we really need to get out to these contractors, is that changes are coming, and you're going to need to look at a contract, even if you think if it's a renewal, same thing you've been doing forever for the government. There may be a lot of different requirements that you need to start paying attention to that before maybe you were supposed to be paying attention to, but maybe they were, like I said, a self-attestation, and now someone's going to be knocking on the door. So
that's right. That's right. And for all you mom and pop small business and medium-sized businesses out there in government contracts and subcontracts, that's exactly my client profile. I specialize in helping out those small and medium-sized businesses that don't necessarily have the same amount of contract support that a large company like Lockheed or Raytheon has. So that's where I come in. I help out these businesses on an outsourced basis as a consultant, so that they can kind of get an equalization of the playing field. They can get a heavy hitter just like Lockheed or Boeing has, but you get it at a fractional price because I only charge you when you're using my services.
All right. So we need to spread the gospel about you to everybody. All right. To get into a little bit more specific question here. So what is a flow down clause in the context of negotiating government contracts?
So a flow down clause would be a clause that is found both in the prime contract and in the subcontract. They would be similar, duplicated clauses. So as a very easy example, let's just call it a cybersecurity clause. So your company, you get a contract with the US federal government, and then the contracting officer, they include that cybersecurity clause in your prime contract. Now, you are going to use a subcontractor for some of the work. Remember, that's going to be a second contract. Your company, will have a second contract, a subcontract with another company, another subcontractor. Now, if you were to duplicate all or part of that cybersecurity clause into your subcontract, we would call that a flow down clause, because that clause and its requirements would flow down from the government first to you as the prime contractor. And then from you, the prime contractor, you would be flowing it down into the subcontract, so that the subcontractor would also have to perform and adhere to those requirements. So that's how we say that these policies through the contract clause will flow down from the government's requirement to the prime contractor, and then from the prime contractor's flow down clause within the subcontract. And just to underline the point, Dana, this is exactly why it's so important, not just for prime contractors. Some of the businesses out there, they operate exclusively as a subcontractor. Many of my clients, in fact, operate exclusively as a subcontractor. But this will affect them just as much, because most of these cybersecurity clauses that are already out or will be coming out, they are in fact required to be flowed down, as we've just learned. They're required to be flowed down by the prime contractor into all of the subcontracts as well.
Are you having a hard time finding new customers? A lot of folks just like you in the IT and cybersecurity space are in the same situation. And they have embraced a new opportunity to get new clients. They're doing this by growing their online presence and maximizing the power of LinkedIn. How, you ask? I have a tried and tested method called my Cyber Social program. I myself have been on LinkedIn and now have over 3.5 million LinkedIn views, and over on YouTube, I have over 750,000 video views. So I can show you exactly how I have done that so that you can promote your organization and become the authority in your industry. And the best part is, I've done all of this organically without one paid ad. You don't need to waste your money over on Google with pay-per-click ads. Now's the time to establish yourself. Look around. The competition isn't doing it. This is your time to shine online before they do. So if you're ready to start your online journey and future-proof your business, please, down below, click the link and schedule a time for us to have a 45-minute call where I can review the exact methodology of the Cyber Social program. You can also click below to see some of my masterclasses, which will give you quick little snippets of a couple of things you can do right away on LinkedIn that will help with your profile. I hope to see you and hear from you soon.
So now we're affecting even more people. So this is why, again, this is so important. Mm-hmm.
That's right. That's right.
Yeah. And it only makes sense that, prime contractors are going to do that because they're not going to hold the responsibility of the subprime, which they're going to be ultimately responsible for if they don't require that they, are securing the data the way that they're supposed to be securing it. So
that's right.
Yeah,
that's right. Dana, that's exactly right. And that's how to understand these flowdowns. How else could the federal government impose these requirements on a subcontractor? Because remember, the sub, they only have a contract with the prime contractor. They do not have a contract directly with the federal government. That's where the flowdowns come in. They're really the connecting chain so that the government's policy, like cybersecurity, would flow down to all the subcontractors and not just stop with the primes.
Mm-hmm. Oh boy. Okay. Well, here's another one. So what is a self-deleting clause and why are they so dangerous?
Oh boy, the self-deleting clause. Yeah, well, I just gave a speech to a cybersecurity conference in Huntsville, Atlanta about this, and I called my speech the myth of self-deleting clauses. I would tell you that self-deleting clauses are mostly nonsense. This is something to be very, very skeptical about. I would call it a poor or underhanded negotiation ruse or ploy or underhanded tactic, because basically self-deleted clauses, it's very misleading. It's when a prime contractor is negotiating with you as a subcontractor, let's say, there will be all these flowdown clauses in there. Some of them should be in there. Some of them must be in there. And then some of them don't need to be in there at all, right? They're just extra fluff, or they create requirements that really shouldn't be there and that you should not accept as a subcontractor. There may be like 50 of these such flowdown clauses that do not belong and are actually very bad for your company. So if you follow the self-deleting clause nonsense, you might push back as a sub and you go, hey, wait a minute, there's like 50 clauses that don't belong. Can we delete these? Please, Mr. Big Prime Contractor, could you delete these clauses? Well, Mr. Big Prime Contractor, they'll come back and they'll say, oh, don't worry about those. We'll just leave them in there, sign the subcontract anyway. Those are self-deleting clauses. Now, here's where the deception begins, because let's just think it through. Let's just think it through for a minute. Are these clauses that are supposedly self-deleting, are they written in magical disappearing ink? No, probably not. Is this like a movie in James Bond and Mission Impossible where the clauses will just self-destruct and pow, the contract on that page will just burst into flames because it's a secret message? Absolutely not. Those clauses will be there. You signed that contract, right? So another thing to think about, Dana, if they say, oh, that's a self-deleting clause, you don't have to worry about it, you don't have to follow it. Well, you might reply back and say something like, okay, well, if it's a self-deleting clause and it won't matter to me, so you say, why don't we just delete it right now, right? So logically, there's always going to be a problem with this whole idea of a self-deleting clause because, we can discuss it more. There are ways that a clause might not apply, but the idea of just waving your hand and saying, oh, it's a self-deleting clause, don't worry about it, 99.5% of the time, that is not accurate. that is a trick that's going to get you in trouble. And it's really just a way of your negotiating partner kind of pushing you to sign. So I'd be very careful about that. Very careful. In fact, I think in all three of my books, I have a chapter dedicated to this, or at least a paragraph or a section dedicated to warning everybody out there about this whole self-deleting clause nonsense.
Well, and that's an excellent point that you're bringing up here. And I think that we're going to see a lot of this with CMMC because some of the subprimes may not have CUI, controlled unclassified information. They may only have FCI, federal contract information, if they even have that. They may not even have that. So for them to say, well, you need to be CMMC certified at maybe like a level 2, and maybe they don't, maybe they do a very, very, very basic thing and they don't have any other highly sensitive information or whatever. But for ease of use, the prime is saying that all of their subs need to achieve level 2, for example, CMMC. And if they say to them, well, we don't even do anything like that for you, and exactly what you're saying is going to come into play. Oh, well, don't worry about it then. But then, like we always say with anything, nothing is a big deal until something happens. And then everybody goes to the contract, as I'm sure you are well aware. Mm-hmm.
Yes. And so let's talk about that. So clauses are not self-deleting. There is a way that you could write a clause to be self-deleting as they mean it to be, but I can tell you in my practice, I've literally never seen a clause like that. I've never seen a clause that says, based on these contingencies happening, this clause will actually be stricken from the record without a further modification. It's never like that. It's never like that. So they're using imprecise language to talk about something else, and then they use this strange label of self-deleting. But there are ways that a clause could not apply or be rendered void or something like that. And so let's briefly hit on those. A clause could be in your contract and then not apply if the conditions for that clause are not satisfied. For example, if the business is sold, you must give me notice within 30 days. Okay, well, you don't have to give any notice if the business is not sold, right? That's pretty standard, but nobody should be calling that a self-deleting clause. That's just a clause that has a contingency, right? All the other examples that they might be alluding to when they give you this nonsense about a self-deleting clause, well, they have something in common, and it's pretty dangerous. A clause might be rendered inoperative. It might be ruled to be void or inapplicable by a court, right? By a judge. But remember, you don't want to rely on that. If the clause shouldn't be there, you want to get it out of that contract before you sign. Because the thing that we have in common, when a clause is in the contract, but then it's taken out by a judge or rendered inoperative or said to be illegal or something like that, remember what that has in common. That means you had a dispute. There was an argument. You had a problem, and it got ugly. And then it went to court, right? We're talking about a judge doing something in litigation. So that's exactly what we want to avoid. Contracting professionals like me, we are there to help you avoid litigation, to help you avoid disagreements. And the contract itself, as a tool that we all use for so much business and commerce, it's also designed to make sure that we come to the same agreement in writing. It's to make sure that there won't be any ambiguities or conflicts or things like that that have to be resolved in court. So again, that's why don't be thinking in terms of self-deleting clauses. Think in terms of precise terminology like inapplicable clause or a clause that only applies in certain contingencies. Don't believe the hype about a self-deleting clause. I'd be very skeptical about that.
Yeah, I would too after listening to you. So here's another thing. So now this is one thing I bet a lot of the subcontractors maybe fear is how much negotiation can they really do with the big prime? They're probably a little bit afraid. They don't want to take a chance of losing a contract or anything like that. So, I mean, what kind of flexibility is there with that?
Great question. I'll put it into two camps, two categories. When you're negotiating with the government as a prime versus when you're negotiating between prime and subcontractor. When you're negotiating with the government, you can negotiate. You can, but you have much less flexibility. When you are out there in the world of prime contractor, subcontractor negotiations, you have much more flexibility. There's much greater flexibility in the subcontract negotiation. And so big lesson here is make sure you take advantage of that freedom and that flexibility of contract. if you're negotiating a subcontract, you do have a lot more flexibility to negotiate terms because you are two companies. You're two companies coming to agreement rather than a company dealing with the federal government that is beset by and laden by many, many, many more laws and regulations than two companies that are working out a deal, right? So you're definitely going to have a lot more flexibility as a sub. But you also bring up another important point, Dana, which is the power disparity is often a big factor in that negotiation between the prime and the sub, right? If you're dealing with one of the very large contractors and they have big billion-dollar contracts, if the services or goods that you provide are substitutable, replaceable, if there's many other options for them, well, your negotiation power is getting very small. And you might be worried. You might think, oh, if I push back on anything, the big prime contractor, they're just going to drop me. They're going to say, oh, that company is a troublemaker. They're causing problems for me. I'll just drop them. I'll just go find another subcontractor that doesn't push back on all the contract terms. I would say that's a mistake. Like I said, I do this for a living. I help out companies negotiate their subcontracts and their prime contracts with the government. And I've never had that problem because I know how to negotiate as a professional. I know the rules. I know how to negotiate politely and strategically. And there should be no pushback as long as what you're asking for is reasonable, intelligently presented, diplomatically presented. And as long as it's following the rules, it's pretty much a normal thing to negotiate. So I will say that the power dynamic will influence your negotiation, but it's really more about choosing your battles, right? Rather than avoiding battle altogether, if we're saying that battle is really negotiation. So I encourage everybody to negotiate terms. Be aware of the power dynamic, but don't let that dissuade you from making any changes at all to a subcontract, because that's a very dangerous business practice. Many of my new clients are new clients because they did that. You know, they weren't using my services before. They didn't negotiate anything. They were afraid to. They just signed it. And then they get into big trouble because they can't perform and they have disputes. And I always say, wow, I wish that you had hired me a year ago when you signed, because I could have helped you negotiate that. We could have taken that out of the contract and we could have avoided these problems. So if you're a business owner, if you work in government contracts or subcontracts, don't be afraid to negotiate. Get a professional on your side if you need one, but negotiation is absolutely fundamental to the contract and therefore to the success or failure of your business.
Well, that is excellent, excellent advice. So this was really awesome. So before we go, so what are some clause negotiation tips you can share with us?
Sure. So number one, you got to know the rules, right? Master the rules to master the game. And that probably means having some kind of a government contracts expert on your team, whether they work for your company or whether they're outsourced, like through ChristophLLC.com. You need a government contracts expert. This stuff is complicated. You're talking about millions, if not billions of dollars. One of the most important rules for you to understand is something called a prescription clause. So there's an actual rule in the FAR or the DFARS itself that explains explicitly when that clause must be placed into the prime contract by the government. And there's also a related rule called the flow down prescription clause, and that informs the prime contractor exactly when they have to or don't have to flow down that same clause into all of their subcontracts. So bottom line, there is a secret code. There is an actual rule that you can research and use in your negotiations about whether that clause belongs or not. It's called the prescription clause or the flow down prescription clause. I actually have an online course. It's short. It's about an hour or less. And it teaches you exactly how to find that prescription clause. And it even gives you a playbook, a formula of how to write out a justification to remove a clause from your contract based on that rule that every contracting officer will respect and that every contracts manager at a company will respect. The online course is called How to Remove FAR Clauses from Your Contract or Subcontract. And it's available with the suite of other classes that I have available at courses.christophllc.com. So I'd say know the rules, understand the FAR and DFARs, know about this prescription clause, use it to your advantage, and then don't be afraid to negotiate. And another tip I'd give you too, use red lines. We call red lines the marked up version of the contract. Microsoft Word has this ability to just track the changes. You absolutely have to do that yourself. Track the changes. And if you get a negotiation partner that is not doing that, if they send back a changed contract and there are no tracked changes, you need to enforce that discipline and that standard politely. You need to say, I need you to send me back this version in tracked changes so that I can see what you've actually done. Because they may not be doing this in an underhanded way. They may just be ignorant, but it is standard industry custom and practice to expect to get red lines. It's the only way we can track what was changed, what you changed, what I changed. And so with that, document control is also important. Just things like labeling the contract versions. You know, you go back and forth in negotiations 6 times, that could be 12 different versions of the contract. So you want to make sure you have document control, name the versions of the contract carefully, use red lines, know the rules, hire an expert to help you out with this stuff, and don't think that you'll just fix it later. This is the time to fix it, right? Before you sign the contract, things are infinitely easier to modify than if you were to wait till afterwards, where you might get in trouble. You might not be able to modify the contract later. So it's kind of like that ounce of prevention versus a pound of cure, right, Dana?
Mm-hmm. Yep, absolutely. Well, this was really, really, really valuable information. So I really appreciate you taking the time to talk to me, and hopefully lots of people will get some great help with this. And so ChristophLLC.com, that's the website to go to?
Yep, ChristophLLC.com with the CH and a PH. And then the courses are courses.christophllc.com. The website, the original website will take you to either one if you look around. And then the books are called the Government Contracts in Plain English series, Government Contracts in Plain English, Federal Acquisition Regulation in Plain English, and then Government Contracts Negotiation Simplified is the third book that would cover a lot about what we covered today. And again, I direct you to that course online called How to Remove FAR Clauses from your contract or subcontract, because that's going to become especially important to those of you dealing with these new cybersecurity clauses, whether you're a prime contractor or a subcontractor.
Yeah. All right. Well, thank you very, very much. I really appreciate this. And hopefully we'll have you back on another time down the road for another lovely topic around contracts.
I would love to do that, Dana. It's been my pleasure. It's always great to speak to Dana, the maven of cybersecurity and know-how. You know, we all look to Dana to get that expertise, me included. So thank you for all that you do.
Okay. You're very welcome. I think I play more of like an Oprah role, but
that's fair. That's fair.
Yeah.
Maven. Give yourself some credit, Dana. Give yourself some credit. I will if you won't.
Okay. Well, thank you. I appreciate that. And thank you everybody for watching, and we'll see you on the next episode. Until then, take care. Bye-bye.
Bye now.